If you are Acting Secretary of the Navy, Hung Cao, Assistant Secretary of the Navy, Benjamin Coleman, Florida Congress members, although it really applies to all Congress members, Ashley Moody and Rick Scott, U.S. House member Gus Billy-Rackus, United States Marine Corps Office of Legislative Affairs. I need about 10 to 15 minutes of your time, so if you're not them, feel free to stay, especially if you're a military family, because at some point this may apply to you as well. My name is Danielle Charlton. Last year, my husband, Gunnery Sgt. Kenneth, Kacey Charlton, suffered a massive brain bleed, which eventually led to the diagnosis of grade 4 glioblastoma, a terminal brain cancer, and a diagnosis recognized by the Department of Veteran Affairs as a service-related injury due to his deployments in Iraq and Afghanistan. This diagnosis has been devastating for our family, and there have been days where my husband of over 15 years does not recognize who I am. At the time of diagnosis, my husband had served faithfully in the United States Marine Corps for 18 and a half years. He was looking forward to his retirement and celebrating with our friends and family. We had planned to pursue IVF again in 2025, but obviously that could not happen. Last year, my husband issued me not one, not two, but 3 powers of attorney, durable and healthcare. For him to be able to retire with his 20 years, he has to undergo a military medical board to determine his fitness for duty. My husband is clearly unfit for duty, and I'm not arguing that. The issue lies with the fact that he is deemed medically incompetent or incapacitated due to his memory issues and diagnosis of aphasia. Can we also eliminate the verbiage incompetent, because it's incredibly insulting and the word incapacitated gets the point across exactly the same. In order for me to assist him through his medical board so that he can retire, SECNAV orders loosely state that Government Disability Council may only discuss the case with a court-appointed guardian, not a spouse holding a durable power of attorney. And while I understand that these orders are in place as a protective measure for the service members, if the service member already has appointed someone with a durable power of attorney, they should not have to forego an entire legal document that was notarized by a member of the United States Marine Corps. Within these power of attorneys that I originally held, I was able to pursue legal action on his behalf should the need arise, make medical decisions for him if he was unable to, buy or sell property in his name, and I even sold our house under these same legal documents so that we could move states to seek better health care for him than he was currently receiving. When it was time for the medical board, I was informed that these legal documents that he issued me were not sufficient enough for me to assist him through the legalities of the board, and I cannot fathom why if I can pursue legal action on his behalf. Again, I fully understand that these orders are in place to protect the service members in the worst case scenario, but I truly think that those that make these policies and official orders lack the knowledge of what real-life repercussions are for military families that are forced to enter a court-ordered guardianship to be able to be medically separated, medically retired, or in my husband's case, retire at 20 years. While I acknowledge each state will be different in the rules and laws of guardianship, I'd imagine the fundamentals are the same across the board. When my husband became a legal ward and I became his legal guardian, I didn't even have full understanding of what those repercussions were. So here I am, pleading with the powers that be that make these decisions to please reconsider. I am unsure if those that make these policies and orders are aware, but obtaining a court-ordered guardianship is not free. It's actually very expensive. Each of us had to obtain an attorney, and he had to be examined by a medical examining committee by the state of Florida, all of which come at a cost. The approximate cost for the state of Florida for the initial valuation, court and attorney's fees is approximately $10,000 to $12,000. The court fees are ongoing for the duration of the guardianship, and every time something needs to be filed, and if we wanted to petition for a reevaluation, that comes with a new set of court and examining committee fees. These are something that the military does not pay for, and the military will not represent military families through these matters. With the diagnosis of terminal brain cancer, my husband didn't just lose his ability to communicate clearly, parts of his memory, the ability to retire and truly celebrate his retirement of 20 years. He lost every single right that American citizens are granted. The same rights that he fought for nearly 2 decades to defend. Due to the guardianship being forced upon us, despite legal documents we already had in place, he lost the right to vote, to make social environment decisions, the right to choose where we live, the right to his own finances, the right to contract, the right to his own medical choices, and the examining committee even tried to revoke his right to travel with his legal guardian, me, his wife of 15 years. And while I do allow those decisions to be made within our household, they were revoked from him in the eyes of the law. I'm not denying my husband's cognitive deficits, but I am advocating for his rights, his choices, and his health, just like I have for our entire marriage, but more specifically, the last year and a half. You see, with a legal guardianship, even between spouses with long-term and established marriages, all finances have to be separated. The only money that I, as his legal guardian, can legally spend from his paychecks has to benefit him. I'm unable to work because I am his full-time caregiver. The money that we have transferred from bank account to bank account for our entire marriage can no longer happen. I have to save every single receipt for every single penny spent from his account and submit them to our state for a review to ensure that they match the bank statements perfectly. I cannot begin to describe how stressful it is that one missing receipt or one discrepancy in his accounts, and I can have the title of his fiduciary revoked by the state, meaning I would have no control over our household finances. When we relocated for better health care for him, the guardianship was not in place yet. I was able to sign a lease for our new rental using the durable power of attorney he granted me. But now, a year later, as we are about to renew that same lease, we're facing extreme difficulties due to something as silly as his signature. His signature that now has no legal bearing. Now, multiple people are having to jump through hoops to figure out how to reconfigure things as ridiculous as lease agreements and digital signatures because of this guardianship. Let's circle back to the IVF. As stated previously, we had plans that we made together that once our fertility clinic opened a location closer to us in 2025, that we would pursue another round of IVF in hopes to expand our family after battling infertility for 14 and a half years at the time. Kacey had an oncology appointment this week, and we discussed new tumor growth and then his need to restart chemotherapy. When you're on chemotherapy, it's incredibly unsafe and ill-advised to conceive. You're not even supposed to share bathrooms when someone is undergoing chemotherapy. We were advised this week that if we wanted to continue with the family planning aspect, we needed to do so as soon as possible so that he can receive his chemo treatments. And if it weren't for the guardianship that, again, was forced upon us due to SACNAV orders, we would have already moved forward with it. But because my husband's right to make any decision at all legally has been revoked, we quite literally have to ask permission from the state of Florida to move forward with our plans to expand our family via IVF both medically and financially. So I will end this long-winded video with urging those that make these policies to please reevaluate them and think of the long-term effects they have on your service members and their families. Because the guardianship doesn't end when the medical board does. And there's a good chance that the state the service member resides in will not reverse the guardianship. I'm not asking for the guardianship to disappear completely because I acknowledge that there are situations where it is necessary. But what I am asking is that when a service member has already executed a valid durable power of attorney, naming someone to act on their behalf, that document should be honored for the purposes of the disability evaluation system whenever legally appropriate, instead of automatically requiring a court-ordered guardianship. I'm not asking anyone to interfere with my husband's current medical care or the retirement process. But what I am asking is that this policy be reconsidered so that after his retirement and for future military families, that there's a less restrictive path when valid powers of attorney already exist. Military families carry enough burdens after catastrophic injuries. We shouldn't have to sacrifice fundamental civil rights just to complete a medical retirement. Thank you.